Hello everyone, kumusta po kayo? I hope that you're all doing good. Investing in real estate is not always a simple transaction of just buying a piece of land simply because you have the money or the resources. Hindi naman po kasi sa lahat ng pagkakataon ay nakikita agad yung problema o obvious agad yung problema dun sa property. Minsan, nalalaman mo na lang na may problema pala yung lupa na nabili mo pagkatapos na ng transaction and you have already parted away with your money, meaning nabayaran mo na yung seller and getting your money back is next to impossibility dahil naggamit na ito o nagastos na ito and there is no way for the seller to refund your money kahit nakasuhan mo pa. In the recent years, maybe you're aware na naging patok at uso yung agri-tourism o agricultural tourism industry sa Pilipinas. May mga nag-venture into converting their farms into tourist attractions which gained popularity among local tourists. Lalong tumaas ang interest dito ng karamihan, lalong-lalo na nung kasagsagan ng pandemic when people got exhausted and overwhelmed by the restricted movements, especially in the cities and urban areas. And yung mga may financial capacity naman ay bumili ng mga farm lots sa rural areas and started making farming and gardening as their hobbies. Well, for me, that served as a good respite and a way of relaxation. Subalit hindi lahat ng naging transaction sa lupa, whether it is a home lot or a farm lot, ay naging smooth and peaceful. As expected, there were problems which arose from these transactions. Isa na po dito yung lupang nabili na bago pa man nalaman o na-discover na nakapaloob pala ito sa Ancestral Domain Claim or Ancestral Land Claim or Ancestral Domain Title o Ancestral Land Title. Minsan kasi dahil sa excitement and upon seeing that the property is ideal for your farm or your dream rest house, minsan nakakalimutan nating i-check kung talagang safe ba to. Sino ba naman kasi ang makaka-resist kung ang property is situated in a rolling area kung saan langhap na langhap mo yung cool breeze coming from the green surroundings o di naman kaya overlooking a river or a stream or a lake where you have the perfect view of the sunset or the sunrise. Diba ang ganda nun? Yung tanggal na ang stress mo habang nakatitig ka lang sa paligid mo. But if you want to get rid of that stress altogether, make sure naman na hindi rin stress ang hatid sa'yo ng lupang binibili mo. If I need to, I would emphasize all the time that you need to do your due diligence first before you buy a real property. Part of this due diligence is to make sure na hindi sakop ng ancestral domain o ancestral land yung lupang binibili mo, whether it is still a claim or it is already titled, whether as a CADT or as a CALT. CADT stands for Certificate of Ancestral Domain Title, while CALT stands for Certificate of Ancestral Land Title. If it is part of an ancestral domain claim or ancestral land claim, we should be aware that there is always that possibility that the government will issue a title in favor of the claimant in the future. And it is up to you whether you want or you are willing to take the risk. You might ask, Attorney, what if may titulo yung lupa na bibilin ko, kaya lang nakapaloob ito sa isang ancestral domain claim ng isang clan? Kagaya halimbawa ng emancipation patent title o CLOA title o homestead patent title. Safe ba ito? Well, kadalasan po kasi pag sinasabing ancestral domain claims, ito po ay consisting of thousands of hectares. I have seen an ancestral domain claim na sinakop na ang buong barangay o buong isang municipality na halos. Well, it should be safe dahil nakasaad naman po sa IPRA Law o RA 8371 na property rights within the ancestral domains already existing and or vested upon effectivity of this act shall be recognized and respected. So, kung existing na po yung title o yung certificate of title, whether it is a judicially issued title o administratively issued title, nire-respeto po yun ng batas. Sa katunayan, sa ilalim po ng delineation guidelines ng NCIP na kasaad po na vested and existing property rights referred to in Section 56 of RA 8371 shall be fully recognized in accordance with the legal terms contained therein, but shall not be a bar to delineation and recognition of ancestral domains or ancestral lands. A vested right or existing right is some right or interest in property that has become fixed or established and no longer open to doubt or controversy. Vested rights include free patent, homestead patent, sales patent, emancipation patent, certificate of land ownership award, and judicially decreed titles. Lands covered by such titles shall be segregated and excluded from the ancestral domains or ancestral lands. The vested or existing rights of any person within the ancestral domain or ancestral land shall be respected, provided, however, that the rights holder shows and submits proofs of such rights to the PDT or CDT. But if you are presented a title na CADT o CALT at ito po ay ibinibenta sa inyo, if I were you, I would resist the temptation. Dahil in the case of ancestral domain po, ito po ay itinuturing na community property that belongs to all generations at hindi ito pwedeng ibenta. Nakasad po sa Section 5 ng IPRA Law na Indigenous concept of ownership sustains the view that ancestral domains and all resources found therein shall serve as the material basis of their cultural integrity. The indigenous concept of ownership generally holds that ancestral domains are the ICC's or IP's private but community property which belongs to all generations and therefore cannot be sold or disposed or destroyed. It likewise covers sustainable traditional resource rights. Pagdating naman po sa ancestral lands, pwede lamang po itong ibenta sa kapwa nilang miyembro ng community. Nakasad po sa Section 8 ng IPRA Law na the right of ownership and possession of the ICCs or IPs to their ancestral lands shall be recognized and protected. Such right shall include the right to transfer land or property rights to or among members of the same ICCs or IPs subject to customary laws and traditions of the community concerned. By the way, ICC stands for Indigenous Cultural Community while IP stands for Indigenous People. Pero may nakitang loophole po dito ang mga bihasa sa ating batas. I'm referring to lawyers. Ito po yung paragraph B ng Section 8 ng IPRA Law na nagsasaad na in cases where it is shown that the transfer of land or property rights by virtue of an agreement or device to a non-member of the concerned ICCs or IPs is tainted by the vitiated consent of the ICCs or IPs or is transferred for an unconscionable consideration or price, the transferor ICC or IP shall have the right to redeem the same within a period not exceeding 15 years from the date of transfer. It is being construed or interpreted na pwede namang ibenta ang Certificate of Ancestral Land Title o CALT as distinguished from CADT as long as hindi naman vitiated yung consent ng Indigenous Cultural Community or Indigenous People na nagbenta nito at hindi naman unconscionable yung price. Meaning, wala namang panluloko o pandiling lang na nangyari at sakto o tama o adequate naman yung price na ibinayad. Dahil kung vitiated ang consent o unconscionable yung price, the Indigenous Cultural Community or the Indigenous People can redeem the property within a period of 15 years from the sale transaction. This for me is a tenable assertion that supports the argument na in the case of a CALT, pwede itong ibenta sa non-member of the indigenous community as opposed to a CADT na hindi talaga siya pwedeng ibenta. I hope that you have learned something from this video. Please feel free to share your thoughts in the comment section below. And if you think that this channel can be of help in providing you with useful and relevant information, please feel free to subscribe to this channel and hit that notification bell icon so that you will get notified of our future videos. Always remember, ignorance of the law excuses no one from compliance therewith. I will see you in my next video. Ingat po kayo.